can, Your Honor. Can you hear me?
I can, thank you.
Go ahead.
This is Santa Cruz County versus Audit USA et al. It's C20223426. Please announce your appearances.
Your Honor, Justin Pierce on behalf of the county plaintiff.
And Bill Reisner on behalf of John Brakey and Audit, and with me is John Brakey, the defendant.
Good morning. The court set this hearing as a status conference, having received the mandate from the Court of Appeals. And I thought the first best steps would be to try to discuss with counsel where we go from here. I didn't want to presume that you all wanted this court to continue to hear the case, because obviously you have I'm no longer on the civil bench, and you also have the ability, I think, to file a notice if you want. I haven't seen one, but I didn't know how you all wanted to proceed and what next best steps we had. So, Mr. Pierce, what do you suggest, sir?
So, defense counsel and we had some back and forth on this as to what the next best step would be. My feeling was that that with the return to the Superior Court, I think the mandate specifically requests the court to consider the fact that there was another public records request, whether that satisfies any concern about an actual case of controversy. Our feeling on this would be, and if the concerns are that we're going to keep litigating procedural matter back and forth, let's just get to the issue of the question of what the declaratory relief is. Are the CVRs covered by the protection of the statute or not? And let's just brief that issue. That, to me, would seem to be the quickest way to get to the answer without having to go back and forth of whether there's a case for controversy. I think that our position is obviously that if there is a case for controversy that is subject to a declaratory relief action, and we're just trying to get that guidance here. Our feeling would be, I think that the complaint needs to be answered. It hasn't been answered yet. Set a date to answer the complaint, set a date for an opening brief, set a date for a response brief, set a date for a reply brief, put an oral argument on the calendar if we want, and to me that's all that is necessary in the case to move forward. If Judge, if you're not on the civil bench anymore, will it get assigned to a new judge then, regardless? And when we weren't planning to notice, I mean, that wasn't we never planned to do that. But if it's going to be, does it make sense then to I guess to set an oral argument wouldn't make sense, but we could at least set a briefing schedule then, maybe to brief the issue, and then it can go to whatever judge it gets assigned to, and if that judge wants to set oral argument, then great. If not, wants to decide it on the briefing, then great. That would be our position in terms of the most efficient way of moving forward.
Mr. Reisner, what do you think?
Yeah, he's suggesting that we just go to the merits of his claim, which means a full-blown lawsuit, and we're not interested in that at all. This is there were 49 paragraphs in their complaint. They want to do a big lawsuit. They want to do all that stuff. We've got other things that we're interested in, and so there's nothing about ripeness. We're being drug into this case when we've got other things that we want to do. We don't want to proceed down that road, and to say, well, this is contrary to the way public record cases work. You file a record, they give a response, and then the person who makes the request decides what they're going to do. So this case is all manufactured by Santa Cruz County that wants this lawsuit, and in a stunning way. I mean, they sent a letter saying, we agree that cast vote records are public records. We've provided in the past, and we'll give it to you by 5 o'clock on the 18th. and then not so much as a phone call or notice or consideration or anything. There's a complicated lawsuit that they put together to imagine how there would be a case or controversy that's based on a different group that went to court, based on a different set of things. And they say, well, it's right because we just don't know what to do. If we were to turn it over, we're facing horrible criminal prosecutions and blah, blah, blah. If they want an answer, why don't they ask the Attorney General for, there's a whole statute that is set up for an office to give them an answer that they want. But that doesn't involve us. We have other things that are going on with this organization. We did get passed in the legislature a bill on the ballot images. The governor had an objection. Another bill's pending. The group's working on another aspect that nationally will have an effect on things. We got stuff to do. If they've got a question, ask the Attorney General. We don't want to be in their lawsuit, and there's nothing about mailing in a request and have it on file, which my client did. There was no indication that we wanted to file a lawsuit. We said in the motion, in our response to the motion to reconsider, that we weren't going to go to court. We don't want a lawsuit. We filed a motion to dismiss, and the court sent it back for consideration of the effect of that. And I don't know if they read that part of it or not, but our position is quite clear. And this is a decided imposition to suggest that this is something that our little organization or my office should spend a whole bunch of time and go back up to Court of Appeals, because they want an answer that they could get by simply asking the Attorney General in Arizona what the answer is. Thanks.
Ms. Pierce, anything else?
Yeah, I just want to respond to a couple of those points. One, could we seek an Attorney General opinion? Of course. That's not the only option. I mean, I know that that's what the defendants want in this case, is for us to do that, but they don't get to decide what course of action we believe is appropriate to get the best answer to this issue. An Attorney General's opinion is just that. It's an opinion. It's not binding. Second of all, if they're concerned about it, this is not a huge lawsuit. In fact, the only reason it's gotten where it is the fight on the procedural matter. If we just simply move forward on the question, they don't even have to, they could simply respond and say, we have no position on this, court, make a determination. And they don't have to spend a bunch of time and effort on this. We just simply need to know, are these CVRs actually protected by law or not? There's some question out there because of exactly what the defendants have noted here, that even when we initially responded to the public records request, they're right. We said, yeah, we're looking at items 2 through 6, and we'll get those out. Number 1, we can't because those are protected. Well, in the meantime, then as we're this is how public records request goes. Then the attorneys review, and as we're getting item number 2, the CVRs, it's like, hey, wait a minute. Our position is these are the same things as the ballot as number 1. We can't disclose these without having a real problem. Well, yeah, Maricopa County has disclosed them before. Pima County has disclosed them. They've briefed all of this stuff. And I feel like we're getting into the merits here a little bit, but the point is, wow, we've got one county over here that's disclosing them. We've got now a Court of Appeals decision in February of 2023, after all this came down, saying they're not disclosable up in the Maricopa County matter. There's some real question here. All we need is that's why we filed the declaratory action. It wasn't to drag anybody into court unnecessarily. They don't even have to respond. They can respond and simply say, we're not a real party in interest here. We want these records. We don't. If they want to defend it or make the case that the CVRs are disclosable, then great. They can do that, or they can say, Judge, you guys decide if we're entitled to them or not. So the parade of horribles that has been presented as if it's this massive, complex litigation, it's really not. It's as simple as, as a county, do we have to disclose these? We know there's a case for controversy because there's been a request for them. We know that even after the motion is dismissed, there was a second request for them. This is the exact type of case that could evade review, because you could get, even if they say, hey, we don't want to be part of this lawsuit, we're not making this request, we're withdrawing the request. Okay, then the case goes away, and then they make the request again, and we know that there's a history. So there is a case for controversy, and we just want to be able to brief the issue and have the court tell us, are they part of the law or are they not? If the legislature passes another law like they did last year and the governor doesn't veto it, then yes, we would agree. The issue then is moved, because that law was specifically designed to address this issue. But it actually supports our position even more. The fact that the legislature is considering this to try to change that so that they are disclosable, well, then that would suggest that they aren't, if the legislature is moving in that direction. And so we just want clarification. We want to protect county officials from unnecessary actions down the road, whether it be for failing to respond to public records or disclosing things that are protected by law that should be.
Okay. I think I understand the issue, Mr. Reisner, and here's the way I look at it. On the one hand, you and your clients want this to be over with, which I totally understand based on the court's ruling before, and on the other hand, Mr. Pierce wants the court to essentially go forward and have it done on the merits, and I'm stuck in the middle, so to speak. But I think what gives this court instruction is the mandate itself, which specifically says that I should have considered the supplement to the motion to reconsider, and I didn't specifically address that supplement to the motion in the ruling.
Word again, Paul Whitfield, Secretary of Transportation.
I have a supplement to the motion for reconsideration, which the court didn't properly consider based on the mandate from the Court of Appeals. So now I want to consider that. So that is the issue that's in front of this court. Does the supplement to the motion to reconsider, which outlines that there was a new public records request pertaining to the general election and the CVRs and all of those items, does that in any way modify or present the court with good cause to reconsider its previous order granting the dismissal? So pursuant to the rules governing motions for reconsideration, Mr. Reisner, since I didn't consider the motion, I didn't give you the opportunity to respond to it. It's new information that was not presented to the court. I couldn't consider it and grant it on those grounds without giving you the opportunity to respond. So I think the appropriate way to do this is actually to grant the defendant the opportunity to respond to the supplement to the motion to reconsider. And then I'll allow you, Mr. Pierce, to reply. And rather than going to a briefing on the merits, what we're going to go to is the question as to whether this other public records request really makes this a live issue. Does the fact that there's a subsequent request really make it? Maybe it does, maybe it doesn't. And what I'm inclined to do is, while this is a civil matter and I'm not on the civil bench, because it is my initial decision that was being reconsidered or it is a subject, and I have the history with the case, whether everybody's excited about that or not, I keep it until I rule on this one issue. And if for some reason I rule in Mr. Pierce's favor and I believe that we need to go forward on the merits, I will have it reassigned on the civil bench because it's going to go forward as any other lawsuit. If on the other hand, Mr. Reisner, I find for your clients, and I find that my previous order should not be further reconsidered and I affirm it, then it ends for here and goes to the Court of Appeals to tell me where either I was correct or incorrect this time. Does that sound like I know it's a very middle of the road approach, but
No, I understand that, except I do want to make it clear for the court that on January 30th, we did file a defendant's response to plaintiff's motion to reconsider. And that was filed prior to your ruling. So we did it.
You got to forgive me. It's been 15 months, Mr. Reisner. I can't remember 15 minutes ago, much less 15 months ago. But I think what's critical for everybody to understand is you all have so we can do this one of two ways. And I think regardless of how we do it, it's going to be a much more efficient approach than trying to let this go on the merits, like full-blown amend your complaint, file an answer, go from there. It seems to me that the most logical way we proceed is you all know what the court ruled and why, and I was silent on the supplemental motion. So if we want to start back with the supplemental and essentially have additional briefing on that and have an argument on that, I think that makes a lot of sense. But the fact is the record is devoid of any consideration of the motion, and quite candidly, Mr. Reisner, your response, because I didn't consider it. I didn't.
Okay.
And if I'm going to consider it, and I'm not saying I am, I'm not saying I'm not, other than the fact that I must consider it, I'm not saying I'm going to grant the motion to reconsider, but before I can, I got to hear from you. And so I think the most logical way to do this, rather than relying on pleadings that happened 15 months ago or 14 months ago, let's have some supplemental briefings. If we want, we can do them simultaneously, because the facts are the facts. And we can set an oral argument now, and we can set it for a relatively short period of time, get this case resolved, at least from my standpoint, and whether I find for the plaintiffs and I reinstate the case, so to speak, and send you on your merry way, so be it. Or if I don't reinstate the case and we go on to the Court of Appeals, so be it. But it seems to be a more efficient resolution. I can tell you what is going to be of particular interest in the court is what happened with that general elections public records request. And I don't want an answer now. I'm going to let you resolve that inquiry for you, but I want to know what happened. And you know what the responses were. If that wasn't included in the, because remember I didn't
understand what you're saying.
So remember, the issue before this court is with the supplement to the motion for reconsideration, which the court did not consider.
Yeah.
The whole basis for the supplement was that there was another public records request, and it was for the general election. And not to state it too plainly, but the point was, this is going to keep popping up again and again, Judge. You should go ahead and just rule on it. And what I said was I basically ignored that as an argument, and I said, in looking at what the complaint is and what the status of this case is, there's no justiciable issue. I may have been wrong on that. And so I think I need to know essentially a history of what happened in that second public records request to see if it changes the court's calculus. It may not. But if I'm going to consider it like the Court of Appeals wants me to, I need to fully consider it.
Okay, then from what you said earlier, I would request that we do have an argument date and that each side files a supplemental memorandum on that point.
Sounds good. Is 2 weeks sufficient to be able to file your supplemental memoranda?
I think so, Your Honor. And so we talked about just simultaneous filings and then an oral argument for when the court's available.
Mr. Reiser, a couple weeks sufficient for you?
Yeah, sure.
So let's say April 8th, which is a Monday no later than 5 o'clock, supplemental briefings. No responses or replies, because I will do my best to remember 15 months ago, but I'll also read the record again so that I have a more full understanding of everything that we've gone through. And I will have reviewed all of the pleadings, the motions to dismiss, the rulings, the records that we have, everything. And then the supplemental briefing on the 8th, that you file by the 8th. And then let's come back. I think an hour should be more than sufficient. And I would suggest we come back on April 15th, the following week. At 1:30 would be my preference, but I really have any time in the afternoon.
On April 15th, that works.
And to the extent anybody wants to appear by Teams, they can, because I know it can be difficult to come down to court sometimes. It's all oral argument, and under the civil rules and the presumptions, you'd be permitted to appear if you want to appear in person. I certainly don't have a problem with that either. And we'll set it for an hour. We'll give you 30 minutes to each side. And Mr. Pierce, since it's your motion that I'm technically considering, I'd allow you to have the first and last argument to total 30 minutes. And Mr. Reisner, if you need it, I'll give you 30 minutes for your entire argument. And then I either rule from the bench or take it under advisement or rule really quickly thereafter. Because it really depends on, I guess, what the argument has to say and what the record is that I get on the 8th.
Right. That works for us, Your Honor.
Okay. then we'll see everybody on the 15th at 1:30.
Thank you.
Thank you all. Stand at recess at this time.
Appreciate it, Your Honor.
Hey, thank you, Bill. This could be our last walk from here to the courthouse, huh? We've been, what, how many years now? 20 years?
Yeah, beats the gallows.
Yeah, it does, doesn't it? And who would think that we'd be doing a Santa Cruz County case in Pima County? But I know we're going to do well because I have one of the best attorneys in the country, Bill Reisner. And you know, in the next few months, we're going to plan a big get-together with all his friends and have a happy retirement party for Bill after practicing law. How many years?
55, I guess.
55 years. And I retire after he does, because who's going to represent me after that, okay? Okay.
Maybe it's 56.
56.